With us again for a second interview on the 2022 amendments to the Uniform Commercial Code is Edwin Smith. Ed is a partner at the Morgan Lewis law firm of New York and Boston. Ed serves as a commissioner for Massachusetts on the Uniform Law Commission, and Ed chairs the Uniform Law Commission's drafting committee for these 2022 amendments. Welcome, Ed.
Thank you for having me, Don. It's nice to be back.
Well, so today's topic is the Uniform Commercial Code's new Article 12, titled Controllable Electronic Records. What does this new Article 12 cover?
Well, this is the article that is intended to address what people often refer to as digital assets. Now, I want to mention a couple of policy points in the very beginning. One is that the drafting committee wanted to be sure that what it was doing here was what we call technologically neutral. In other words, we were not drafting for today's technology, we were drafting not only for today's technology, but technology that may exist in the future, that we have no conception of today. So if you look to, for example, what people had to go through during the pandemic, where they said, well, can we have electronic contracts? Can we have electronic signatures? And people looked at eSign and the Uniform Electronic Transactions Act. They realized that those statutes worked, and they were drafted 2 decades before. So that's what we hope is going to go on here, that we're going to draft in a that we're going to have provisions that work not only for today's technology, but technology in the future. And so you won't see references to blockchain, you won't see references to distributed ledger technology, you won't see references to public key and private key. So let's talk about a little more about what these provisions, what this article covers. We start with the idea that while people refer to the term digital asset, asset may be a little bit of a misnomer. If I send you, Don, an email that just says, how are you? That email is a digital asset. It's in electronic form. It's a record in electronic form, but it really has no value. So there are many digital assets out there that have no value, but then again, there are digital assets that do have value, like virtual currency or like non-fungible tokens that parties attribute huge value to. So what we were doing was trying to capture those digital assets that do have some value in the marketplace that people really care about. So we came up with this subset called a controllable electronic record. Now, and some people just refer to that for short as a CER. But we start off with the idea that we need a record. And the UCC already has a definition of record that can include a record in writing or an electronic record. And then we need to have a record that's electronic. Okay, that's pretty easy too. We just back out writings, and everything that's left that's retrievable in perceivable form is an electronic record. And then the record needs to be subject to what we call control. Now, the easiest way to think about control is to think about the equivalent of possession of a tangible object. That's what we were trying to replicate. We were trying to replicate for this electronic record what you have when you have possession of a tangible object. So if I have the power to enjoy substantially all of the benefits of this record. And I have the power to keep others from obtaining this record. And if I'm the only one who can transfer this record, and I can identify myself to a third party as the one who has control of this electronic record, then I have control for purposes of Article 12. So when you think about this in virtual currency world, if I have a wallet of virtual currency and I have the private key, I'm the one who can keep others from acquiring that virtual currency, putting aside some hacker. But I'm the one who has the power to keep others from obtaining that virtual currency. I'm the one who enjoys substantially all the benefits of that virtual currency because I'm the one who can decide how to spend it or transfer it. And only I can transfer it. And there are ways for me to identify myself as the person in control. So if those elements apply, then I am in control. Now, there was also a lot of market pressure for something called multi-sig. And multi-sig is a situation where, Don, you have a private key, I have a private key. It takes both of our private keys to affect the electronic record, the virtual currency. You and I together then have control. Or if you can transfer control without my consent, or I can transfer without your consent, we each have control. So there's a little bit of a relaxation of the exclusivity requirements. And then also, if you get into a situation in court where you need to say, well, I have control, and I'm the one who has the exclusive right to prevent others from acquiring this this electronic record, or I'm the one who can transfer the electronic record. I don't need to prove that no one else in the world has those powers. It's presumed that I have those powers unless contrary evidence is evidence. So why do we care? Why do we care whether I have a controllable electronic record or not? And this is where we get to the private law rules. The question under Article 12 is, if I'm a transferee of this controllable electronic record and I have control, what rights do I have? Don, you transfer control of this controllable electronic record to me. Under Article 12, I get whatever rights you had. But if I'm an innocent purchaser of this controllable electronic record, what we call a qualified purchaser under Article 12, I take for value in good faith without notice of any adverse claim to this controllable electronic record, this adverse property claim. I cut off all competing property claims to that controllable electronic record. So what this does is it really makes virtual currency negotiable, which is really how people treat it in the marketplace. So we've satisfied that particular element of the market pressure. Now, how do we deal with trade finance? If you look at a controllable electronic record, it is possible that that controllable electronic record has embedded in it other rights. If you think about a promissory note, you have a paper promissory note and you have embedded in it a right to payment. So it's conceivable that you can have some other right that is embedded in the controllable electronic record. And there are those who have these wonderful views about how distributed ledger technology, especially in the future, is going to be able to be set up in ways in which other rights can be transferred. Don, you could Venmo me $1 million and I'll email you Blackacre, because for you to get control of this controllable electronic record, Blackacre travels with it. We thought about trying to get into all of that, to what extent these embedded rights will travel with the controllable electronic record, and to what extent the transferee then would be able to take the same rights in the embedded right that it would take in the controllable electronic record itself. And we decided that was way too vast an area to get into, that if parties want Blackacre to be traveling with a controllable electronic record, the real estate bar is going to have to come up with a set of rules that will supplement what we have to make that work. But there's one area where we did get into embedded rights, and that drives us back to trade finance. And that is where there is a payment right that's embedded in the controllable electronic record. So if the payment right is an account under Article 9 of the UCC, or a payment intangible under Article 9 of the UCC, then the account debtor, the person obligated to make that payment, has agreed to pay the person in control, then you have what's called a controllable account or a controllable payment intangible. And the advantage of that is, if you have a transferee who obtains control of the controllable electronic record, the controllable account and the controllable payment intangible travel with that controllable electronic record, and the transferee gets the same rights in the controllable account and controllable payment intangible that it has in the controllable electronic record. So if it's a qualifying purchaser of the controllable electronic record that cuts off all competing property claims to the controllable electronic record, same thing happens with the right to payment, the controllable account or controllable payment intangible. Those are taken free of competing property claims as well. So what we have done is really used Article 12, not only for virtual currency, but also to create an electronic record, an electronic promissory note. And if you then have, as part of the record, the account debtor, the person obligated to make the payment, also agreed not to raise claims or defenses that it has against the transferor, against the transferee, then what you've done is you've made that electronic promissory note an electronic negotiable promissory note. So that's how we responded to the trade finance community. Now, there is also the question of what the poor account debtor does. How does the account debtor know who to pay? And we really follow the same rules that you have in Part 4 of Article 9, 9406, so that the account debtor can continue to pay the person in control until it's notified that someone else has control, and then it pays that other person who is in control. But there's a hook here, because when you're dealing with a normal account or a normal payment intangible, the account debtor can say, "Who are you? You're a stranger," and ask for proof, reasonable proof, that there's been an assignment to the transferee. And that can easily be shown by seeing a security agreement, for example, or a factoring agreement. But when you're dealing with controllable electronic records, that might not be possible to do. So the idea is that the account debtor and the person in control, which could be the original person, have to agree in the record for an effective way for the that notification to be given and the proof to be shown. And so if they agree in advance and the proof is shown in that way, then the account debtor gets its discharge by paying the transferee, and it can no longer get a discharge by paying the transferor. And then we have choice of law rules as well. I'll just mention very briefly that if the controllable electronic record has a governing law clause, and that jurisdiction's substantive rules govern the controllable electronic record. As a general matter, if There is no governing law clause in the record itself. The system in which the controllable electronic record exists has a set of rules that has a governing law. Then you look to that jurisdiction, substantive law. And otherwise, you look to the substantive law of the District of Columbia, which we think is highly likely to adopt Article 12. If it doesn't, then you follow the official text. But that's the residual rule that would apply to most virtual currencies like Bitcoin or Ethereum, is you look to the governing law there. Now, a lot of people may say, well, how in cross-border transactions, how is that going to work? Well, this is where our coordination with a lot of other foreign lawyers is helpful, as we see a confluence of the substantive law rules with what we're doing in Article 12. So choice of law rules only matter if you have different substantive law rules, and if the substantive law rules are functionally the same, you end up with the same outcomes, and that may well be where we end up. And that's a long summary of Article 12, but that's what it covers.
Well, okay, so that's fascinating, but what does it not cover?
Now, that's great. That's a good question. First of all, if you have an electronic record that is not subject to control, it's outside of Article 12 entirely. You follow whatever the other law rules are. So you have to have an electronic record that is subject to control. Also, if you apply the definition of controllable electronic record across the board, writ large, you pick up a lot of transactions, especially under other articles of the UCC, that are working quite well. So a controllable electronic record does not include electronic chattel paper, electronic documents, investment property, money, which we might get to in another session, deposit accounts, transferable records under UETA Reside. Those are electronic records, and they are arguably controllable electronic records, but they work quite well, and we didn't need to disturb a lot of the rules relating to those particular types of assets. So they're out as well. And then last, I just want to emphasize that Article 12 deals with the private commercial law rules. It doesn't get into other areas of the law. It doesn't tell us whether a controllable electronic record is a security or a commodity. It doesn't deal with the taxation of controllable electronic records. It doesn't deal with whether a money transmitter law or license is required. It doesn't deal with anti-money laundering laws. We just stayed with the straight commercial law rules.
All right, well, thank you. So one more question. Why is it article numbered 12 rather than 10? or is this like these, football conferences that can't count?
Well, I get this question all the time. If you can believe it, a lot of times from state legislatures. When the 62 and 72 amendments to the UCC were promulgated, the transition rules were in Articles 10 and Article 11. And there are a number, and although those transition rules now have been withdrawn from the official text of the UCC, there are still states that have Articles 11 and 12, 10 and 11 on their books. So we thought rather than mess with that, we would just go right to Article 12.
Well, that makes sense. So, well, Ed, thanks for your wisdom on this again. Greatly appreciated. And I'm wondering if we could impose upon you at least one more time to come back and talk about other changes to the Uniform Commercial Code in the 2022 amendments.
Don, I'd be happy to do that. Especially, I ought to get into secured transactions and treatment of electronic money. So maybe we can put that on our list for the next time.
Well, thank you. Appreciate it very much.